Good afternoon, Dylan here. This is week number 7 discussion board, and I chose to look at the 5th and 6th Amendments. When we think about our rights as citizens under the Constitution and the Bill of Rights, two of the most pressing considerations is that of the right of the accused to a speedy and public trial as guaranteed by the 6th Amendment, or the right not to be held for capital offenses unless indicted by a grand jury per the 5th Amendment. My question is, does this apply to military dependents, whether it's their spouses or children living in a foreign country? And according to the Constitution, in Article 1, Section 8, Clause 14, Congress has the power to make rules for government and regulation of land and naval forces, which leads to yet another question. Does this apply to strictly military active duty personnel? Or does it apply as well to civilian citizens who are accompanying their military personnel? And then also, does it apply during war, or does it also apply during a time of peace? Now, in 1956, the Supreme Court has got two cases on their docket that they would be deciding in June of 1956, to be exact. Kinsella versus Kruger, which is located at 351 U.S. 470, or Reed versus Covert, 351 U.S. 487. These are going to be trials of a capital nature. They were tried, these are two wives, they were both military dependents who had been tried under the Uniform Code of Military Justice. And they were tried for the capital offense of murdering their spouse. Now, in these cases, they were not given a trial of jury by their peers. They were not indicted by a grand jury, but rather the military investigation done under the Naval Criminal Investigation Service. Yes, NCIS is a real thing. They decided that there was enough evidence to put these women on trial. So they did. And as such, they gave them a military court-martial. Now, if you are not familiar with the military court-martial, there are 3 different types of military court-martials. But for these particular cases, the special court-martial was what was applied, which meant they had a judge, a prosecuting attorney, a defense attorney, and a group of 5 individuals who acted as their jury. Now, these were all active duty personnel. So right there, you're starting off on the wrong foot because you've got a military judge, 2 military lawyers, and a jury of military individuals. So these were really and truly the peers of the victims. And they are eventually convicted, and they are sentenced to life in prison. Well, they're sent back to the United States, and the fathers of the 2 women who had been convicted actually will file a suit that will eventually reach the Supreme Court case, asking, was Congress able to allow under the UNCMCJ to try and convict their daughters without violating their 5th and 6th Amendments? And initially, the U.S. Supreme Court does actually side with Congress. They did actually side and say that, yes, that there was cases in the past that they had agreed with that said that, yes, those civilians could be tried under the UMCJ. But in the second term, when they would reevaluate this case, they would actually overturn their own decision. Reed versus Covert was actually the stepping stone. It was the first one that actually overturned the fact that the U.S. Congress had no jurisdiction whatsoever to set forth and create laws of military civilians. That they could, however, in times of war, try civilians who accompanied their military personnel, but they could not try civilians in time of peace. That it was indeed a violation of their 5th and 6th Amendment, the right to a speedy and public trial, because court-martials are not public. They are closed-circuit trials where nobody is in attendance but the accused and those who are part of the whole court, as well as their right to be indicted by a grand jury. So in 2006, led by Senator Lindsey Graham, they would actually rework the law so that military civilians accompanying their active duty personnel are actually better protected now.